What were the likely mistakes being made at Champlain Towers South that led to this tragedy? Well, noted attorney Adrian Adams, Esquire, founder and managing partner of the Adams Sterling law firm, sets the table for our discussion by outlining the common mistakes he sees boards making on the subject of maintaining their buildings, and shares the three-part business judgment rule that is designed to guide boards towards making effective decisions.
I'm going to give just a brief background on the Champlain Towers and what, as of today, what the status on the towers and the legal implications. For all of you, I'm sure you've seen, it's a 40-year-old building in Florida. It was 12 stories tall, 136 units, and the average condo sold for $100,000. So it was a nice condominium complex, but not what would be considered a luxury complex. And I suspect that the $100,000 range is because partly they kept their dues down by deferring maintenance. And that was one of the problems, is that they had low dues and tons of deferred maintenance. And in fact, less than 3 months before the collapse of the towers, the board president had sent a letter to the members warning that damage in the building had gotten significantly worse since the 2018 inspection. And in fact, the engineer in that inspection had said in his written report that concrete damage would multiply exponentially in coming years. And he had noted in the 9-page report that there was water intrusion coming in from virtually everywhere, from window frames, balconies, the pool deck, planters, and the water was leading to structural damage. And he had noted abundant cracking and spalling in concrete columns, and in beams, and in the walls, and significant cracking in the exterior stucco, which would, if you've got water going into the walls, could lead to also mold. And he had recommended additional study to find out basically the extent of some of these. And the association had then followed up with the cost to repair, which was a $15 million fix. And when you have a fix that large, it shows decades of deferred maintenance. And in fact, the special assessment was going to range from anywhere from $80,000 to $200,000 per unit, depending on the particular size of the units. So that, of course, inevitably led to a lot of wrangling and delays and infighting and directors resigning from the board as they grappled with just how to go about making these repairs. And then ultimately, before anything could be done, the building collapsed. And as of today, there are 97 confirmed dead and another, 50, 60 that are missing. And in fact, one of the missing is a board member. So as of today, also, about a dozen lawsuits have been filed, and a criminal investigation has been opened. And named, of course, the association, individuals, very likely board members, have been named. The building inspector, who had said the building was in very good shape just 2 years before the collapse, and he's now on a leave of absence. The city of Surfside has been named, and very likely because of poor building standards and code enforcement problems. The engineering firm that inspected the building in 2018 and pointed out all these problems has also been named. And they're arguing that the engineering firm should have actually gone deeper in the studying and looked at the structural issues more deeply, and should have notified the city of the problems. And then also the neighboring condominium building has also been named in litigation. It was because construction, this is very similar to the Millennium Tower in San Francisco, which was sinking and leaning. When they filed suit, they sued the city, and they sued also construction from next door, claiming that it was part of the problem, that the construction led to problems with the building sinking. And so how this impacts board members and managers. When they have something like this where they know they've got a lot of deferred maintenance, and problems, and then something ultimately happens that results in litigation, there's going to be a lot of discovery. And what's going to happen is not only the current board members for Champlain Towers, but probably prior board members will be certainly part of the discovery process. There are going to be depositions, emailed traffic between them will be studied intently to find out what did the board know and when did they know it and what did they decide to do or not to do. And obviously, there were prior boards that decided not to do anything and to defer maintenance and do Band-Aid fixes, which is what then led to the crisis that they were at that was documented in 2018. And so what does that mean for these boards of directors? Are they going to be personally liable? Well, certainly there's going to be attempts to make them liable, and one of the defenses that they're going to make is the business judgment rule, which basically states that the decisions, if a board member makes a decision in good faith, in the best interest of the association, and after reasonable inquiry, they're not going to be personally liable for any mistakes in judgment that they make. So they're going to be focusing on the issues, these issues of maintenance and what decisions were the boards making. And unfortunately, I've dealt with boards where they've decided that it's in the best interest of their members to keep dues down, and they'll go for 10, 15 years or more with never raising the dues. And that's a huge mistake, because all that's doing is ensuring that at some point there's going to be a very large special assessment in everybody's future in order to play catch up into making repairs. Now, as of today also, there are at least so far 5 insurance carriers involved in the litigation. There's already been a hearing initially in the courts, and 2 of the carriers have already offered to pay insurance limits, which were $3 million on their policies. And the court has appointed a receiver to take over the association's monies and handle things on behalf of the association. And of course, there's right now they have nowhere to go. All of the people who did survive have to find temporary housing. And the court has authorized the receiver to pay out monies to the individuals so that they can at least have some temporary housing. But there's also a criminal investigation going on, so that there's probably going to be an attempt to pin somebody with criminal negligence. And that is at least the state of things for that particular, those boards of directors. And it's probably going to reach back a number of years for prior boards. So the takeaway here is that for current boards of directors, they need to pay attention to the maintenance. That is their number one obligation, is maintenance. That's why an association is created. That's why a board of directors is elected, so that they can take care of the common areas, because somebody has to do that. So that means boards of directors need to be looking at their budgets. They need to be raising dues if necessary, at least to keep it up with inflation, and to set aside appropriate reserves so that repairs can be made.
At Association Reserves, we make the present less stressful and the future more secure. If you want to join us in this mission, please like this video and subscribe to our channel. Leave a comment down below on what you'd like to see us address in a future video. Let's plan for your best future.